You guys know what's ridiculous? It's that I try my best to make your videos not super long. And then we talk about these subjects and I get all passionate and fired up. And then I realize I've gone 10 minutes in and I'm only halfway through. So I have to start over. So that's what I'm going to do right now. I'm going to start over with this um, on the Scott versus Sandford case. Now, you've already learned about this in class. So that's why you don't need a two 10-minute videos or something. And you know the basics, you know what's about. I've seen the work you've done, and that's good. But what I'm trying to do here is to make some connections for you guys about the stuff before and after Dred Scott case, not so much all the specifics of the case, but also to show you some of the big questions that it raised and some things that you might not see in the average textbook, so to speak. Yes. So I'm even going to set myself a timer right here so that I don't go too far. So 1857, all right? That's before the Civil War by a couple years. So keep that in mind. Now, let's first talk about slavery and the courts. We learned a little bit about Chief Justice John Marshall. He really avoided the controversial issue of slavery while he was Chief Justice, and he was replaced by Roger Taney. And he was from Maryland. He was appointed by President Andrew Jackson. He was the Supreme Court Chief Justice from 1836 to 1864. A little trivia fact, his wife Anne was the sister of Francis Scott Key, who you should know wrote what became our national anthem. This statue was recently taken down. And I had this conversation with Miss Schweitzer last week, how I was amazed that he even had a statue. I know that there were Southern general statues that were being taken down, but Taney is just not a well-respected person, really, by any U.S. historian that I know. And we'll get into some of those reasons why in a minute. Okay, now, this is stuff we're reviewing. We've already discussed slavery and the Constitution. So let's look at how this led to the Dred Scott case. We already said even before the Constitution, you have the Declaration of Independence and how Jefferson wanted to get rid of slavery, or just at least say how evil it was there. But the South wasn't really having that. So even at the convention, there were those who wanted to abolish slavery, but it wasn't really possible because our southern states would not have agreed to it if it abolished slavery, and you needed to get the Constitution going or the country would fall apart. So like, okay, we'll address slavery after. And really, they thought that slavery was on its way out the door anyway. We have Article 1, Section 2, Clause 3, which is the 3/5 compromise. We learned about that, where 3/5 of the slaves are to be counted in determining a state's population to see how many people it would have in Congress representing them. Article 1, Section 9, Clause 1, Congress would not prohibit the importation of any more slaves before 1808. So giving like a 20-year buffer, figuring that in after 1808, it could be, the importation could end. And then Article 4, Section 2, Clause 3, where you have the Fugitive Slave Clause, which requires runaway slaves to be returned to their owners. And we already discussed how, was that part of the Southern power theory, so to speak. So by the time Taney became Chief Court Justice, you have slavery threatening to tear the country apart. And then how the expansion of U.S. territory increased the tensions over slavery as an issue. The country was moving west and adding territory in these states, and the debate began over whether they should be free or slave, right? This is review. We learned about this. So we have the Missouri Compromise of 1820, where Missouri would be slave and Maine would be free, and slavery would be prohibited above the 3630 parallel. So now comes the question, what about slaves taken into a free territory? Dred Scott, picture of him here. He was owned, so to speak, by an army doctor, Dr. Emerson, and his work required him to go to free areas, and Scott went with him. When Emerson died, his widow Irene inherited Dred Scott, Harriet, and their children. Scott tried to purchase his and his family's freedom, but it was turned down. He took the case to Missouri and won. His argument was that I'm a free citizen of the country and I have a right to sue for my freedom because I lived in a territory where slavery was forbidden. However, the decision was repealed or it was reversed on an appeal to the Missouri courts. By the time it went to the Supreme Court, the defendant was John Sandford, who was Mrs. Emerson's brother-in-law. Look at the court, and this is important. 7 of the 9 justices were appointed by Southern presidents. Think of that theory again. And 5 came from slave-owning families. And now the issue becomes, who is a citizen? Okay, in the Constitution, it might not say citizen, but it says, the people of the United States. According to Taney, citizens in the Constitution are recognized as people whose rights and liberties were violated by the British government. So neither the people who were imported as slaves or their descendants, free or not, so even free blacks, were acknowledged as part of the people, and they were regarded as beings of an inferior race, unfit to associate with the white race, either in social or political relations, and therefore were not citizens. Scott was considered merely just an article of merchandise, really, at this point. So the Taney court decided that people of the U.S. and citizens meant the same thing, and that slaves or their descendants could not be citizens. So therefore, how could they even sue? They can't even. This case can't even happen because he's not even a citizen. He can't even sue us. It also declared that the Missouri Compromise was unconstitutional because nothing in the Constitution gives Congress the power to deal with slavery. This was the second use of judicial review that we learned about since 1803's Marbury versus Madison. It's important to know that this decision was not unanimous. Justice Benjamin Curtis of Massachusetts, he was the first justice to actually have a law degree. That's not a requirement. He was also the first to resign on principle. And why did he resign? Because he really made this made him upset. He wrote a 70-page dissent, which inspired lots of ideas by others opposing slavery. Even Abraham Lincoln used it. So the results were that the references to Curtis's dissent pushed the movement forward as far as ending slavery, as for equal rights, and all those sorts of stuff. It is considered by almost any scholar in U.S. history to be the worst decision in the history of the Supreme Court. That's why that statue had me amazed. It had a big effect on the country. Southerners supported the ruling and believe it settled the slavery issue once and for all. Oh, they're not citizens. It doesn't, whatever. Northerners rejected this ruling and viewed it as an abuse by Taney and the Supreme Court. If you read what our founding fathers wrote, read the Federalist Papers, I always cite that. They sort of referred to the Supreme Court will make mistakes, but it's possible that then the U.S. can fix those mistakes. And this case would be an example of that. Dred Scott did return home a slave. He was later set free later in his life. The Civil War comes a few years later. This was never officially overturned, but amendments did come later. You have the 14th Amendment, which declares anyone born in the U.S. a citizen, and that states cannot deny any person equal protection of the laws. So the 14th Amendment overturns it in its own way. You also have the 13th Amendment, which abolishes slavery. So that addresses this as well. Okay, so like I said, this is a really hugely important case. We can talk about it more. If you have questions or something you want to focus about, please let me know. And I'll see you next class. Look at that, under 10 minutes.